Good afternoon, everybody. This is Adam Gordon from Candidate ID. We're going to get started in probably 2 more minutes. We tend to kick off at 2 or 3 minutes past midday, just because a lot of people are coming out of meetings and tend to work on a hour-by-hour basis, and I can see the number of attendees is going up and up. So one request I would have is, if you're on the session and you know you've got colleagues who are also on the same session, if you wouldn't mind maybe doubling up and doing it on the same login, that would be really good. And the reason for that is because we've got room for 101 logins, and we have 144 individuals who are signed up. So if you could consolidate yourselves, that would be really, really good. But you're still going, the numbers are still going up. So yeah, I'm going to give it maybe 2 more minutes, and then we'll get started and introduce Helen. Okay, hi everybody, and thanks very much for joining our talent talk. We do these talent talks roughly every 2 weeks. We normally have a subject matter expert. We often have an in-house recruitment leader come and join that as well and just give their context. But in this particular session, we felt that we didn't want to divert from Helen. So we've got the three, I think, the 3 hottest topics in the news right now are Brexit, North Korea, and number 1 by far is GDPR, as we all know. So that's why we wanted to make sure that we were doing this session. Helen and I have known each other for a number of years, since she was Chief Operating Officer at Odgers, the executive search firm. And over the last year or so, Helen's been specializing in data, and specifically the GDPR. So we're going to have, Helen's going to talk for about 30 to 40 minutes, and then we'll have a little bit of room for some questions as well. And so I'm just going to hand over controls to Helen right now, and Helen can introduce herself a bit better than I've just done, and talk us through the most important aspects of GDPR that we need to be thinking about.
Great. Okay, let's just do this. So hi everybody, thanks for tuning in today. Hopefully my screen, yeah, it's going to play ball. Okay, great. So look, what I'm going to do, I'm going to try and keep it really practical, not make it dry, because I'm sure you've all heard lots of presentations about what the GDPR is from lawyers and various different people. So I'm going to give about 7 slides about what the GDPR is, just in case anybody's been asleep for a little while. And then I'm going to move into some stories that demonstrate how it actually applies to recruiters and some scenarios and actually what you'd need to do. So I just want to check you can see my full screen. Is that okay? Adam, is it fine?
Yeah, absolutely. We can see that.
Okay.
No problem.
Great, super. So a few quick reminders of the key points. It's a European regulation that's going to be brought into British law. It comes into force on the 25th of May, 2018. Earlier this week, you may have seen that the UK government published their bill on the proposal to bring it into UK law and the amendments they're going to make to that. So basically, it's a GDPR plus a few extra things which make it a little bit more onerous for us. It affects all companies with offices in the EU or the European Economic Area. It also means that if you're processing data of EEA citizens, even if your company is not based in Europe, then you still have to comply with this. So this is really interesting piece of regulation, because even if you are in the States or America, wherever you are, then if you have to take notice of this. The other thing that's due to come out is, if one isn't enough, there's another regulation that was due to come out on the same date, but it's going to be delayed. Nobody knows exactly the date. And a lot of people get confused about these two things because this is around privacy and electronic communications. And a lot of people talk about these two things as if they're the same. That they're not, but we can talk about that a little bit later on. But that has an impact on how you use marketing data, etc. And both of these regulations have the same level of fines, which are quite eye-watering. But just not to be sort of alarmist about that, because I don't know if you saw, if you want to actually connect with me on LinkedIn, that would be great, because I'm posting a lot of things about the GDPR. Yesterday, the ICO, Elizabeth Denham, the Commissioner, she put out a piece around fake news and the GDPR, because obviously there's a lot of misinformation, a lot of alarmist stuff, and basically her message was, you know, don't just focus on the fines, because they're not interested really in fining people. That's not the top line. It's about the intent behind the GDPR. So at the actual centre of the GDPR is not data. It's about an individual's right to control his or her data. So it's basically a human rights piece of regulation, which a lot of people miss. So it's giving the individual more rights than they currently have to around their data. So that's for any company that's holding your data. You have the right to request to see what's being held, and you can request that for no fee. At the moment, it's a £10 fee, which doesn't sound much, but it is a barrier to people asking. You can require the data to be deleted. You can require it that's corrected if you don't like what you see. You can actually object to people processing your data. So if you don't like what they're doing with it, then you can ask them to stop processing your data. You can ask for your data to be... Yes, sure.
Really quick question. Could you just give a definition of processed? What does that mean?
So that's basically whatever your business activity is with that data. So whatever... I'll come on to this a little bit later on, but essentially every company needs to set out their process, their basis for processing, okay? So you're doing certain things with people's data, which is an activity. So whatever your business activity is, so in this case it would be you're using data for recruitment purposes, then they can object to that. Does that make sense? Yeah? So it's defined by company. I think actually that's worth something saying as well, because this is generic regulation. It's quite difficult sometimes to understand how it applies to your actual business context, but hopefully I'll make a little bit more sense for that for you. So you can require your data to be transferred to another company, another provider, and you can see particularly where that makes sense. Where, for example, if you were on Facebook and then there was another cool social media site which everybody wants to go over, you could ask for all of your data from Facebook to be transferred to, whatever the next cool thing was. So people get a little bit tied up about that as well. Oh, sorry, we're going the wrong direction here. And then the other thing is transparency. And this is a kind of, if you want to think about one key word for the GDPR, is transparency. Is it clear to the individual what data is being held, why it's being held, and how it's being used? So when somebody gives their data to a company, is that clear? What's going to happen with that? Because you might think you're giving your CV to somebody for a particular job, but actually they're going to use that CV for all kinds of other reasons. So transparency is a really, really big kind of word in the GDPR. So that's around the new rights of the individual. And then obviously, because there are new rights, companies, so recruitment companies, would need to take responsibility and respond appropriately to those requests. So if somebody asks to see their data, you have to show them what's being held within 30 days. So that's a fixed time scale. And what the UK have just come out with this week is that you cannot, when they request, decide to delete some of the data because you don't want them to see it. So you might be holding something that you're not very kind of comfortable with them knowing that you were holding. The proposal under the UK bill is that actually becomes a criminal offence, which is really quite strong and shows how much this is going to be taken seriously. So obviously that's got to still be taken into UK law, but that's the current proposal, that you have to show at the point that somebody asks you exactly what you were holding at that point. If somebody asks you to delete their data, you have to do that. You have to correct it. If they ask you stop, using my data, then you have to stop doing it. If they ask you to transfer, you have to transfer it. And obviously, you need to be transparent. So that's a big requirement that when you are collecting people's data, you are being really clear to them what you're doing with it and why. Okay, so failure to do any of those things is what's called a breach. And one of the terms you might hear quite a lot is data subject. So basically an individual under the GDPR is called a data subject. When somebody asks for something to be done, it's called a data subject request. If they ask to see their data, it's data subject access request, or known as a DSAR. So you'll just hear those terms bandied around. So what do recruiters exactly need to do? So what the GDPR requires is that you assess the risks and mitigate the risks you create for others. And I'll explain that through some examples a little bit later on. So in order to do that, you need to look at how you organize yourself to protect data. You need to look at technical measures in order to protect data. If something goes wrong, you have to monitor that and report a breach within 72 hours. And if you assess that the risk to an individual, so say for example you had lost a file of candidates, or say if you're in interim management, or if you're in contract and you're actually paying people, you've got their bank details and you lose their names and address and their bank details, don't wait. Basically, you tell those people as soon as you possibly can that their data is at risk, so they can take action and be aware. There's a 30-day rule, which is quite a challenging one, that you really shouldn't be keeping people's data on your database if they're unaware that you are holding their data for more than 30 days, and I'm sure we'll have some discussions around that. You need to have a legal basis of processing your data, which is what I talked about earlier, and that basically is a policy that you need to have on file that explains what you're doing, why you're doing it, etc. And we can also talk about that. So legal bases for processing data, there are 6 main reasons, but some of those apply to public authorities, etc. So the main ones for a recruiter would be you get somebody's consent, and there's a lot of discussion about you have to have people's consent. You can have under contract, so obviously if you've got a client, you need to hold their data. But there's a third one called legitimate purpose, and that basically is you demonstrate that you need to have their data in order to perform a contract, in order to actually do your business. So there's a lot of debate about this. Some people say you have to have every single person's consent on your database. A lot of lawyers say, no, you don't. Because actually, if you take people's consent and you do something that's against their consent, then the fines are double than if you were holding it under legitimate purpose. So that's something that really, really needs to be understood, and I'm sure a little bit later on we can have we'll have some questions about that. But I just want to give you a quick overview at the moment of everything. You mustn't keep data that's not up to date, and also not keep it longer than is necessary. So obviously all these things are quite, sort of generic. What does it actually mean for us? And then this whole transparency piece, you shouldn't use data for purposes other than it was collected. And it's really, really critical that you have documentary evidence of what you've done to prepare. And I'll sort of go on to show that a little bit later on. So it's not just a kind of box ticking, it's actually doing some work, having some evidence, because if you were ever in a breach investigation, then the first thing they're going to do is ask you, where's your legal basis for processing? What do you do? Why are you holding this kind of data? And this is where you need to be able to demonstrate some of these things. Some of these areas are really tricky because it doesn't, what is don't keep data longer than is necessary? What is necessary in a recruitment context? What kind of legal basis? And then, you've got the whole 30-day rule. How does that actually work for us? So, there needs to be a lot of thinking about your policy and thinking about how you can demonstrate why you need to use certain types of data. And it's been really interesting working through this with the lawyers, that a lot of kind of things that you might think, I can't do that because people don't know. Actually, if you put it in the context, then the lawyer's a lot more comfortable with why we're holding data and why we're doing certain things with it. So that's just a quick overview, just to give a little bit of flavour of what how the ICO are dealing with this. It's about understanding the risks, as I've said, mitigating those risks, and building a privacy culture inside your organisation. So again, it's making people in your organisation think about the individual, the risks you're creating for the individual, and assessing that. It's a lot of people think of this as like a data issue, but it's actually a change. I see it as a change management project in organisations, because you need to think about how you're processing, what you're doing with people's information, and how you're protecting it. And if you're in a situation where you have to demonstrate, then you need to have that evidence that you can show that good data protection is a cornerstone of your business. So that's the kind of flavour of the kind of background of what we're trying to work with. And I must say, I can't cover absolutely everything. There are 88 pages of the regulation, so it's quite tricky to put it all into half an hour, but hopefully I'll give you the highlights of that. So I just want to say that. So look, let's just move into some stories. What does it actually mean, understand risks and mitigate risks? So I don't know, I love stories because they kind of take everyday situations, so it helps you understand. So if you kind of imagine...
Helen?
Yeah, sure.
Helen, really quick question. Is that your house?
No, mine's much bigger than that. So yeah, this is like a typical house of GDPR consultants, of course. So if you just kind of imagine a situation where you have a friend who's got, for some reason, asked you to look after some cash for them, okay? So if we just think about this kind of analogy in terms of what your friend gives you money, and that's equivalent to data that you're holding of a candidate. Okay, so what you have to, obviously, if somebody gives you a load of cash and you've got to keep it, for a period of time, you think, okay, you start to think about, what am I going to do with this? How am I going to protect this? Okay, so if you just think about a house in terms of your business, you're going to keep this money in your house, and you're going to attempt to keep it safe. So you start thinking about, okay, what are the risks? So some of the risks are, obviously, someone's going to break in when I'm not in, and they're going to steal the money. So you start thinking about, okay, I need to take some organisation measures. I need to make sure I've got locks on my doors. Perhaps I want to put some bars up. I need to shut my windows. So you have kind of policies. You think about, right, these are the kind of things I need to do. So that's assessing your risks, thinking, right, my policies are that I shut my windows and doors and I have locks, or this kind of thing. But then obviously, it's no good having locks and bars if you don't actually use them when you leave the house. So that's where the process element comes in. You've got the theory, but you need to put it in practice, because if you don't lock your doors, then obviously it's very, very easy for someone to come in. So that's kind of exactly the same situation with your business, that you need to think about, what are we going to do? And then you've got to make sure that people are actually going to do it. So then you think about technical measures. So you think, okay, I've got the safe. I'm going to put it in a safe. I'm going to block it with the code. I'm going to put, so you might think about that in terms of, passwords and encryptions on your IT systems. And you might think, okay, I'm going to put a big fence around my house, a little bit extreme in that kind of neighborhood, I would have thought. But that's kind of equivalent to a firewall. So basically, you're taking some technical measures to stop people actually getting to what you're trying to protect. And then obviously, you know, if your friend says, look, meet me down at, you know, the cafe, I want my money back, when you're walking down there and you walk past your favorite designer store and you see that, you know, pair of shoes or pair of jeans, whatever you're looking for, you don't just nip in and spend the money because you've got the money. It's not your money, okay? So it's exactly the same thing when you're thinking about data. If somebody's given you something for a particular purpose, it doesn't mean you can just use it for something else. So you take appropriate care of something that's valuable. You don't flash it around. You don't just kind of put it at risk. So you have a kind of a policy in terms of, you know, building a culture of privacy. You're kind of trying to protect that and not being ostentatious and flashing around what you've got. So hopefully that kind of explains a little bit of how this kind of translates into a business context. And if things went terribly wrong and somehow you did manage to lose the money despite everything that you've done, you'd kind of have that difficult conversation with your friend, which would be in this context the ICO, who said, you know, what on earth happened here? And you would say, well, look, you know, this is what I did. You know, when I went out, I put the money in my inside pocket, you know, in my house, I had the alarm set, whatever kind of thing happened. And you would demonstrate what you tried to do. Despite your best efforts, the money has gone. So that's exactly the same. It's about processes and the policies that we've implemented, but also having that documented. And that's exactly what the ICO would be looking for, is, you know, our kind of action log. This is what we've actually done. Because things will go wrong, and not necessarily in the way that you think they might. So documentation is really, really key. So, okay, let's move on to some little stories, and it's a shame I can't hear laughter, but Adam, you can laugh on this. But so if we just kind of think about 3 possible situations that could happen in any kind of recruitment, any recruitment business, any recruitment context. So if you've got a PA and she's, you know, sitting on her desk and she gets an email in from a candidate to see her personal data. So she thinks, okay, fine, goes to the database and she looks at the record and she sees that there's some rather unsavory comments made by the consultant on this candidate. So she thinks, okay, fine, she probably wouldn't want to see that. So she sanitizes it and then she sends the information to the woman. Now the problem in this situation is that she actually doesn't check who this request has come from, because obviously it could be a request from anybody who's just created a, you know, I could be anybody at gmail.com. So there's been no check on who's actually received this information she's sent out, you know, all the private details, everything she's held. So what actually happens is with this record is that 2 people's records have got mixed up together. So I don't know whether this happens in your database, but I've seen it happen a lot. People with 2 very similar names, and, you know, the CV is not the CV of the person whose record it is, and, you know, the candidate is, all kinds of things are muddled up, and you have to kind of untangle it all when you're trying to create two separate records. So the woman receives this, and she's actually been tipped off by somebody who's been working at this company that there was some rather unsavory stuff on her, and she thinks that actually these people haven't sent me what was on the database, and also they've sent me data of somebody else who's not me. So there's a number of issues going on here. So what would happen in that case? So under the GDPR, what went wrong? Well, first of all, from the kind of individual's, the candidate's point of view, it was unclear to her how to make a request, because you ought to have a statement that people understand what to do. There wasn't a company policy for handling requests that just came in and the person who received it didn't know what they were doing, they just dealt with it. She deleted data, which she shouldn't have done. And there's obviously no processes in terms of checking, you know, was this the right person, was this the right data, just making sure, you know, that that's being done well. And the employee was completely unaware of responsibilities and risks. So in that scenario under the GDPR, if that person complained to the ICO would investigate, and there would undoubtedly be fines and possibly even criminal charges for that person who has been who changed that data. So how could you mitigate that happening in your business? Well, first of all, make sure you've got a candidate data privacy statement which explains to the candidates how they can access their data, what they need to do that. Make sure you've actually got a policy and an appropriate process, so that's you've got control over what's going outside of your business. So I've just mentioned the process, and you can put all of these things in. And it's exactly the same. If you're in any organisation, you can have the best policies and processes, but unless absolutely everybody knows what those things are and they've been trained, then the chances of that happening are zero. And obviously, just think about, if you use a lot of temps, you need to make sure that people understand exactly what they should be doing, because the risks to you are really high. So if that happens, say for example, this employee had actually been through training, you had got the policies and processes, you had got the privacy statement in place, and the ICO came in and said, okay, what happened in this? Why did this breach happen? Why did this person delete the data? Why wasn't it dealt with properly? If you could show all of those policies, then actually as a company you've done everything you could possibly do. Obviously your employees are not robots, so just because this person decided to go off piste and do their own thing is actually a mitigating circumstance for you, and it's extremely likely that you would either have a reduced fine, or actually if your documentation is good and you've shown you've mitigated the risks, then actually you probably get off with no fine. What you might want to do is fire that person who deliberately defied basically your policies and processes. So, two exactly the same scenario, but two very, very different outcomes could come from that. So scenario number 2, this is about a last-minute consultant and the request to see his personal data. So kind of a similar sort of thing. I don't know whether you've got any of these last-minute consultants in your place, but in this case, he had this request came in. He didn't do anything with it, just left it. It was a little bit of a tricky one in any case, and then he went on his holiday. Whilst he was on holiday, the company had a complaint in that a candidate had not received the information that they had requested. The company was completely blindsided to that because they didn't even know this request had come in. They didn't even know, where it had landed or what had happened. So they couldn't action it. So what went wrong there? So essentially the consultant was unaware, or he just ignored it, that there was a 30-day limit. And one of these requests comes in, it is like a ticking time bomb in your business. You need to deal with that, okay? So as soon as it comes in, so that's why probably having something like a risk register or somewhere where it's logged, so not just one person knows about it, is really, really important. Obviously, management needs to be aware of this because this is a potentially ticking time bomb. It needn't be, but handle it as such. So the request wasn't handled within the timescale, which is a breach, which then, when you get an investigation, if there's a complaint about that, then that's going to be extremely costly and fines the management time. And I don't know if you've ever been involved in any kind of investigation from a sort of third party, and that is extremely time-consuming and costly. So what could be done to actually make this work? So obviously having those policies and processes in place that we talked about earlier, having everybody trained, there's no excuse from anybody. Once this comes in, they know exactly what to do with it. That you've got your risk management policies in place, so if somebody goes off sick, this is going to be dealt with within a certain number of days. That you've got that process in place so that people know what to do and how to approach you, so it doesn't land anywhere in the organisation. And then if you do all of that, you get the request, you deal with it on time, business as usual. And again, if it had gone wrong and you have an investigation, you can demonstrate all of these things, then essentially reduced or no fines. So the last one, which is an IT-related one, consultant working on a laptop on the train on a highly confidential search. And of course, it's always the highly confidential search that a piece of recruitment that you are likely to have a problem with. So in this scenario, the company policy is that people do not use their own laptops outside for anything to do with work business. This person had a last minute thing to do, didn't have time to grab the laptop, emailed something to home, and then was working on something on the train. Left it on the train, and then, he didn't say anything at work because he thought, well, the chances of somebody actually finding it and looking at what's on there is not big. So again, the company was blindsided in that. So, in this case, there was an inadequate protection of personal data because the laptop wasn't encrypted. It's interesting that if your laptop is encrypted and you lose the laptop, that's not seen as a breach. But if you lose it and it's not encrypted, that is seen as a breach. So one of the requirements now is that you need to notify the ICO within 72 hours of becoming aware of the breach. In this case, the company didn't know, although the individual knew, he should have flagged it. So the first time they heard about it is when it was published in the newspapers that somebody had found this, and then they were in investigation situations. They had no chance also to manage the reputation. The other requirement I mentioned earlier is that if you have lost something like bank details or something that's really going to potentially cause harm to people, then you need to notify those individuals as well. So in this case, again, you're going to have fines, you're going to have damages, you're probably going to lose your client, and worse still, you're going to end up having damage to your reputation, which is much more difficult to repair. So how could that have been dealt with properly? Obviously, an IT security policy, making sure that you have assessed how you can make your IT secure. Obviously everybody uses mobile devices, but there's ways of making those a lot more secure. Making sure that staff are trained on those policies and also their responsibilities. If they do something wrong, they need to kind of own up to that, so you can manage that. You need to have a procedure in place for reporting a breach. And if you did all of that and the ICO came in and said, how is this data on the laptop? How is it left on the train? Who did this? And you could demonstrate that, Joe had left it on the train, actually had been trained, you had got policies, and he had just decided to do this off of his own bat, then actually, again, you should have either no fine or reduced fine. So again, you could decide you want to take action on Joe. So those are kind of sort of situations which hopefully you can relate to for your business. So a lot of people I talk to sort of say to us, well, actually, we kind of, everything's kind of balanced. We kind of feel we can kind of keep things under control. But when you start thinking about it, actually, the balance of triggers for something going wrong aren't actually within your control. You think about, you've got third-party suppliers who are holding your data. What are they doing with it? What are your staff doing with your data? And then you've got pressures coming from people outside, for example, disgruntled candidates, aggrieved ex-staff, or unhappy clients who actually want to try and, make a point with you. So this is a way that people can actually get back at you. So if you don't have the sort of, your ducks in a row in terms of your policies, procedures, and you haven't got any training, then actually, if you add then professional hackers and professional chancers, it's completely out of control, and you really, really are at risk. So don't panic. What can you do there to pass the GDPR test? So look, here's some examples of exam questions where people have just written a really flippant answer. Okay, so I love that.
I am laughing.
Okay, good. I particularly like why are there rings on Saturn? Because God liked it, so he put a ring on it. And the teacher's written Saturn was not a single lady. Excellent. Yeah. So look, what the ICO were looking for, and this is what GDPR is demanding of companies, is that you do the necessary work. And it's very much like, I think, of the exam question. You show your workings. And you might not get to the right answer in terms of what the ICO might think is the right answer, but at least you can show how you got to where you got to. And I'm not trying to say you don't take it seriously, but because there aren't you know, hard and fast things that we can say, this is how it applies to recruitment, this is exactly what it means. You need to do that kind of homework in thinking about what is a reasonable thing for me to actually do here, and that actually demonstrates I'm caring about people's privacy and I am really trying to comply with this regulation. So hopefully that sort of helps in terms of how you can do it. So what that means is, if you do this work around looking at, you know, your policies, your security, your processes, this is all kind of like armor to you and putting weight back on your side. So no matter what happens, and you know, you will get people trying to do things, possibly, that you've actually got a demonstration of that you did try and that you've given this a priority in your business. And that is what is really, really important. So it's not going into panic mode, it's just thinking about how can I actually demonstrate this and make it work. So what does it actually mean? So people say, well, you know, I think we're okay. But don't think you're okay, check you're okay, because that's the absolute beginning of it. So if you haven't made a start on this and you want to make a start on it, I have got a free, aren't I very, very kind, GDPR online gap analysis audit, and that gives you sort of 70 questions. It doesn't take you very long, it's all yes and no, to give you a bit of an idea of what you need to look at in your business and how you need to approach this. And that's obviously work for recruitment businesses. So, you know, you probably will find there are some holes, but, you know, this is all around risk analysis. Everything in business is about risk. So you need to think about where are your biggest risks, because you can't, you know, you can't work if you're not willing to take risks. You know, in life you have to take a risk. You have to, you know, you go out in your car and you might have an accident, but, you know, that's one of the things that you just have to take a risk. But obviously there's some risks that are really, really not worth taking with the GDPR, but you need to think about what can you do, what are the kind of big ticket items that you can really fix to make sure there are no massive holes in your bucket. A lot of people say, well, you know, what's the worst thing that can happen? You know, probably the ICO are not going to come knocking on my door. That's true. The ICO are not interested in just proactively coming and knocking on people's doors like candidate ID saying, you know, come on, Adam, show us, you know, what you've got. The only reason you'll have the ICO knocking on your door is if something has gone wrong and there's been a complaint or a breach has been reported, and then they will come and investigate. And as I've demonstrated, that is not inside your control. Okay, so some of it is inside your control, but if you do a small amount of work on it or no work, then the chances that something going wrong are quite high. So a lot of people say, well, you know, what's the worst that can happen? Well, I think the worst that can happen is basically your reputation goes up in a puff of smoke, and that is really, really not worth gambling with. So it does need a change management project. It's not just a database project, it's not just about data. And I think because the GDPR is, you know, general data protection regulation, people think this is about data. It's not about data, it's about protecting people's rights. And the first recital of the GDPR is that data privacy is a human rights issue. And if you think about it from your own perspective, you want to make sure that whoever's got your data is looking after it and it's safe, and you're not going to be sort of put in a compromised position. And it's exactly the same for you. You need to think about the individuals that you're dealing with, and are you putting them in a compromised situation by not looking after their data? So I would like it renamed, you know, as being a good demonstration of privacy when recruiting, is thinking about people's privacy. Is what you're doing appropriate? Are you compromising their privacy? Are you not being transparent with what you're doing with their data? So very conscious that time's ticking on. So head over to our website if you want to find a little bit more about what we do. We only work in the recruitment sector. We're working with a very reputable law firm, CMS. So I won't dwell on that because I know we've got questions. So email me if you would like to have the audit. And see a lot of you connected with me on LinkedIn as well, so that's great. So enough of me. Questions?
Great. Thank you very much, Helen.
Pleasure.
I have got to say first that anybody who has any questions can feel free to put them in the questions panel on GoToWebinar, which some people have already been doing, or alternatively, you can send any questions on Twitter if you just use the hashtag candidate ID. So I'm going to be a bit self-indulgent and ask a question of my own. So,
Okay.
as you know, we're at Candidate ID. We're already serious about making sure that we are on the front foot when it comes to the GDPR.
Yeah.
Now, what are the big data? What are the big variances between how you need to approach things if you've got, say, applicant data from your applicant tracking system versus what we would be storing, which is really is talent pipeline data. So it's the people that you want to hire now or in the future. And it's very much from a marketing perspective as opposed to from a an applicant perspective. Are there big differences?
Okay. Yeah, there are. So for marketing, you have to have people's explicit consent in order to market to them. So it means that people have to actively opt in order to receive marketing data, marketing approaches from you. So that is a tricky one and a big change. So it's no, if you've collected data through a website and you've just assumed that and there's a box that's already ticked saying I would like to receive marketing, whatever, then that's now not going to comply with the GDPR. It has to be them actually going and putting a tick in the box, not removing it. So that is one of the really, really big changes. In terms of your applicants, that's a lot simpler because they've actually, applied. So you could say that's legitimate interest. They know you're on your database, etc. So if you were using, for example, if an applicant says, I sent you their data and they think they're just applying for a role, you need to be transparent with them at that point about what's going to happen with their data after that. So if you are intending to market to them as well, you need to give them the option to receive that or not.
Okay.
Does that answer the question? Yeah?
So it certainly does. There's a lot more questions that I'm going to be asking you offline between now and the end of the year, as you already know.
I do.
So, okay, other questions. Here's one that I can easily answer, which is from Siobhan, and it's, can we have the slides afterwards? The answer is yes. Everybody that's joined the session will get an email with they will get the video. The recording. So here's another question, which is from Colin, and the question is: if a candidate asks to see their data, what do you physically show them? Do you show them a screenshot of a database, or does it need to be a printout of the data? How do you present it? How do you have to present it?
It doesn't. You have to give it to them in an electronic format. So you don't. It doesn't say. It has to be a PDF or an Excel, whatever. You just have to give them what you've got, basically.
Okay.
And that doesn't just cover your database. It covers absolutely everything that is in what could be called a filing system. So, say for example, you have you've got a little notebook where you keep your kind of top candidates or whatever. You have to show them everything. It's not just electronic records, it's paper records as well. So that can be a bit of a nightmare because you do need to do an audit to find out where you've got data, and that's one of the things that sometimes quite shocks organisations, that they think they've just got data in one place and they start looking, you've got data all over the place. So trying to bring it into sort of central pots is really helpful so you can actually respond to requests more quickly.
So what about archived data? So for example, a lot of our clients are moving from one applicant, an old legacy applicant tracking system onto maybe a more modern, nimble one just now.
Yeah.
And a lot of the old stuff is archived. Is that subject to?
Yes. So anything that you can reasonably put your hand on very quickly, but you can if say if you've got an archive system that you can just go and look, what have I got on Helen Haddon, then yes, you'd have to show them that as well. If it was in an archive that I don't know, that was kept off-site and it was only ever used for just in case you lost everything, and it was not easy to get to that, people couldn't just see that as a kind of everyday regular thing, then no, because there's a kind of test on is it readily accessible.
Okay. Fine, good. So we've got quite a few more questions here actually. How long can we keep data?
How long is a piece of string? So again, there's a 30-day rule for people who don't know they're on your database. In terms of how long you can keep data, that comes back to your individual policy. Yeah. So you need to define that, and I know it's frustrating. I can't give you a straight answer on this, but you need to sort of be able to demonstrate we need to keep this data because, and be able to look the candidate in the eye and look the ICO in the eye if you're ever requested. Why not did you keep the data for this long? And give a reason that actually is plausible and fits with your business reason for holding that. Does that make sense?
It does. Okay, thank you, Eleanor, for that question. I've got a question from Nick, which is how do we effectively manage talent pools? Now, I'm going to ask a supplementary question to that one. Yeah. So how do we effectively manage talent pools? My supplementary question would be: Do you need people to periodically opt in, or is a one-time opt-in sufficient?
Well, again, it's around transparency, isn't it? Because if you had said to people, you've explained to them the reason you want to have their data, and they're happy with that, and the other thing you need to do is you need to, keep records of if people are giving you consent and the fact that you've actually told them what's going on. Then if somebody says that's great, you're working in my sector and I'm really happy for you to have my information, that's absolutely fine. So again, you need to look at what you're telling people, what they've said themselves at the point of collecting the data. Because if somebody said, well, actually, no, I only want, I'm thinking of moving out to a completely different arena and I don't want you to hold that, then you have to get rid of it.
Okay.
So it's again thinking about your policies, being transparent, and looking at slightly more creative ways than perhaps we've got now to make sure that we're engaging with people and that they're aware of that. So I think there are some changes of process and ways of working that there are workarounds, but we need to think about them a bit more closely.
Okay. I'm going to ask Stephen, please, could you be a bit more specific with your question? You've said how is a client's data considered? If you can be a bit more specific with that question, then we'll...
I expect that's about... Okay, so a client's data is necessary to hold under contract, basically. So you can say, obviously, in order to contact your client, your basis for holding that is under contract, or it's actually a legitimate purpose, actually, because you need it in order to conduct your business. However, you need to be transparent with your client if you're going to start using that data for marketing. So, yeah, it's again about the transparency rule. Why have you got that? Doesn't mean just because you've got a client you can start emailing them or marketing to them, sending them, newsletters. So, yeah.
Yeah. Okay. Sorry, Stephen. I don't think you don't need to be more specific about that question.
if that was the answer.
Helen interpreted it far quicker than I did. Okay. So, question from Graham. Does GDPR affect storing candidates' details in a database that have been sourced from a public source? So presumably that means from maybe a
LinkedIn or something like that. Yeah. Well, yes. So when you're taking data, if you're putting data in a database, you ought to be recording where you got it from. And just because, for example, when we take LinkedIn, just because you're taking it from LinkedIn and it's public information, doesn't actually mean that you could put it in your database. And if you look at the terms of LinkedIn, actually, they recently changed them to say you're not allowed to do this. So you need to think about the 30-day rule, and you need to think about how you can work with that, essentially. I think there's also a risk balance here, because if all you've got is, Helen Haddon is a GDPR consultant, and that's all you've got on me, am I going to complain to the ICO about that? However, if you've got Helen Haddon, GDPR consultant, we've talked about 25 people, she's an absolute nightmare, complete witch, don't touch her with a barge pole.
And she's dead posh as well.
So she's got a really big house.
Yeah.
If I asked you for the information and I didn't know it was on your database and that was on your database, I would have an issue with that. Yes, I think you need to think of it, because the risk thing again. What's the reason for holding my data? And if you were looking at, you needed to recruit GDPR consultants and my name had come up, I'd be like, okay, yeah, that's fine. I'd be quite pleased I was on the list. So you need to think about the context and also assess the damage you're doing to somebody. Yeah, is part of this as well. I mean, that's not probably what the ICO would say, but that's what I would say from a recruitment perspective, is just understanding what you're doing and having that basis for demonstrating why you're doing what you're doing.
Okay, good. So next one, brace yourself for this one, because it's
okay.
It's a big one. Thank you, Anne.
Right.
Hi, Anne. Here's the question. Well, what happens when you've got a global database? Do you need to separate EU and non-EU policies?
No. So, okay, when you've got a global database, you need to think, you've got issues around international transfer of data. So if you are transferring data outside the EEA, then you need to put particular clauses and security issues in place. So again, you need to assess the risks. So say, for example, you've got your database held in India, you need to be assessing the risks for that data in terms of security, who's holding it, etc. You need to have transfer agreements between your offices. Obviously, if you're one company, that's quite easy because you just have one central policy for that. And you also need to make it clear to candidates at the point of data collection that you may be transferring their data outside the EEA, and they've got to be sure they're happy with that. Yeah, so again, it's about transparency. And if people say, well, actually, no, I'm not happy with you having my data, and if they say, I only want it held in the European Union, I don't know what you do about that. I would have thought most people would say, okay, your data's all over the place, but it needs to be transparent.
Okay, and just a supplementary question from me about that is where the server is located?
Yeah.
Does that make any difference?
It does. It does. Okay. Yeah. So again, it's part of assessing the risks. Yeah. So if you are transferring data outside of the European Union, then you need to make sure that wherever your server is located, there is the appropriate level of security and agreements in place. So it's the whole kind of supply chain, where you're getting your data from and where it's going to and where it's being held. Yeah.
Right. So the sub-processors and all those kinds of things.
Exactly. Exactly.
Okay. Fine. Yeah. Okay. Got another question, which is, but I think we've covered this. Feel free to answer if you think we haven't covered it. But the question is, what if you're pulling information from public profiles like LinkedIn?
Yeah, I think I covered that. Yeah.
Okay. So, question from Nick: if we do have candidates' explicit consent and they can't self-manage their data, how long can we do?
So say that again. So if they can't self-manage their data,
if they can't self-manage it, how long can we do it for?
Well, that will depend on what you've said, what they've said in the consent form. Yeah. So again, it's the transparency. If you say we're only going to keep it for 2 years, or the candidate says you can only keep it for the duration of this particular assignment you're working on, which is why consent is slightly more tricky, because if people say I only want you to do X, then you've got to conform with that, which can be a complete nightmare if you've got everybody saying different things to you. So yeah.
Fine. Question from James: do we need to delete CV searches after 30 days?
CV searches. Or just explain exactly what that.
It depends where they're. I mean, I guess it depends where they're stored. If your CV search.
Oh, I see. Okay.
On Indeed or something, and you've done a database, a CV search on a job board, for example.
Yeah.
I mean, they're stored within the job board anyway, aren't they? So it doesn't make any difference.
Yeah. I wouldn't have thought so. No.
Question for Eleanor: Can you store? Well, it says can you store information in spreadsheets? A spreadsheet is considered a database, isn't it?
Yes. So anything that it doesn't matter about data. It's basically about any information that you're holding, no matter what format you're holding that in. So if it's in a spreadsheet or in a Word document, a PowerPoint document, whatever you've got, access database, formal database, it all counts. If you can put your hand on it quickly, and it's, you know that this is all the information, we've got information on Helen Haddon here, there, we know that, then yeah, you have to show that.
Okay, question for Robert. I think we've covered this as well, but I'll ask anyway. What's the recommended length of time we should store candidate data? I think that depends on the consent, doesn't it?
Well, it depends on your own policy, yeah. You need to think about the requirement not to hold data that is longer than necessary and not to hold data that's out of date.
Okay.
So, I mean, there's different ways of dealing with that, because if a CV is really, really old, what's the value on that? Are you not better off deleting perhaps or updating it by putting a link to LinkedIn or something instead of actually holding the data?
Yes.
You want to keep the person but put a link to LinkedIn. Wouldn't that be a good way of doing it? It's up to date. Yeah. Lost it.
Okay. This is a really good question. I think from Joe. What are your obligations around a candidate CV that you've sent to a client?
Okay, so you need to make sure that your client is going to take appropriate measures to protect that data as well. Okay, so basically you need to cover that off in a clause, or either with you need to have something which back to back with you and your client to say that you're giving them this data and they have to look after it. It's their responsibility, yeah. But you need to make sure that you're covering yourself off from your liabilities, yeah.
Okay, fine. I'm just going to say, Helen, we've got quite a few more questions. So let's try and do. Why don't we try and do them all? Try and give them a staccatoed response you can.
It's the GDPR question marathon.
Yes, it is. Okay, question from Lauren. This is another great one. Not one I would have thought of, but great question. Can people ask for their data to be deleted if they are out working for us as a contractor?
Well, yes, but why would they do that?
Yeah.
But technically, yes.
Okay.
I think you need a conversation with them about why.
Okay. Question from Graham. Oh, sorry. This refers back to the start of a previous question. It's to do with sourcing passive candidates who have not yet not been approached yet by a recruiter.
Yeah.
So storing data on people that you've not actually made any
approach to
contact with. Yeah.
Well, technically, you have to abide by the 30-day rule.
Yeah.
And I think I answered that. You need to look at the risk thing again. What have you actually got on them? Yeah.
Okay. Right. Yeah, we've answered this one, Anita. Although I'm going to say it because it's a nice message. Hi from Capital One. Question from Anita. How long should we keep data before it can be destroyed?
Well, again, it comes back to your policy. So, you need to think about how useful is it, and are there other ways you can keep that data but not keep things that are out of date, as I mentioned earlier.
Okay, good question from Gordon, which is, when sending data to a client on a candidate, do you need them to opt in to make sure that they are responsible for GDPR also once it's passed on? So has the client got to demonstrate that they are responsible?
Yeah, I think I just covered that, didn't I? You need to have a back-to-back, with your clients, that they can look after the data,
Okay, question from John Rose. If a person asks to delete their data
Yeah.
and asks not to be contacted again, how do you record
Yeah.
and document that?
Okay. This is a really... Okay, so if they ask the data to be deleted, delete it, okay? If they ask you not to contact them again, I would suggest you just put in their name. Some of the database suppliers are actually dealing with this as part of their new kind of features, that there's something in the background which when you put that person's name in, it'll flag up this is somebody who's asked not to be contacted again.
Mm-hmm.
You know, you would have to keep a minimum amount of data. You'd have to explain to the person. I would make, you know, I would just send them something in writing to say, in order not to, you know, you're a really hot candidate, and we really, you know, we're probably going to find you again. In order not to contact you again, you're going to have to just keep a little bit of a record, but not anything apart from your name and perhaps where you're working or something like that.
Yeah.
Or into a LinkedIn profile. Yeah.
Okay. Yeah, the questions don't stop, they're relentless, so I'm going to suggest that we do 2 more, and I'm going to share with you, Helen, the remainder questions that we haven't got to, so that if you're able to respond, you know, one-to-one at some point, then that'd be great.
Yeah, sure.
So,
sure.
Okay, so 2 more, final 2 questions. One's from Tori, which is, what about existing candidates on our database? Do they all need to opt in again? And if we don't hear from them, do we have to therefore delete their record?
So again, it comes back to, I'm sorry to keep on harping on about this, but you need to look at your data and say, where do we get it from? Where do we acquire it from? Would these people be surprised that they're on our database? And you need to assess it. How old is the data? How useful is it? And put some tests around that. Yeah.
Okay.
So there's no hard and fast rule I can give you, but it's use common sense. Think about what you've got.
Okay. Final question from a different Lauren, which is regards talent pools on LinkedIn under the recruiter license, folders holding candidate profiles. What does this mean, if anything, under GDPR?
Well, if you're holding it on LinkedIn, that's all under LinkedIn's policies, etc. So it's not, unless you've got comments on them, which are nothing to do with LinkedIn, then you wouldn't have to disclose that.
Yeah, so so in LinkedIn recruiter license, in those folders,
you have got the field to put,
comments. Yeah, you do.
Okay, well, if somebody asks for that data, then you'd have to give it to them.
Wow. What about if you write it down on a notepad?
If you can put your hand on it easily, you'd have to give it to them. If you had like a pile of notepads by your desk and you have got no clue, you know, whether there is a note in there or not, and it would take you like half a day to check, you wouldn't have to give it to them because it's not. It's what's called a relevant filing system, right? So if it's truly random, it doesn't count. But if it's something you can say, oh yeah, Helen Haddon, I've got something on her, and you can pull out that notebook, then that's a filing system.
Yeah. Okay. Brilliant. As I say, there are other questions. We don't have time for them now. I'll pass them on to Helen. Yeah, no, I'm not surprised you are. Getting your. I think there's a mindset you need to think about here.
Yeah.
I think it makes things a lot easier to understand if you think about it in terms of what a couple of the things that you've said that are to do with, you know, it's a human rights issue. Don't think about it as a data project. Think about it as a change management process.
Yeah, yeah.
And that makes it a bit easier to kind of, you know, put your hand on and identify with.
Sure.
So
good.
Fine. Many thanks, Helen.
Pleasure. Thank you.
And we've had a large number of people signing up for this session today and actively participating with questions and things as well. So it's been very well participative. Yeah. As Helen said, feel free to connect with Helen on LinkedIn.
Yeah.
You're all going to receive a copy of the recording of this session within the next 24 hours. Yeah. And Helen, anything else that anything that you want to say as a sort of final call to action or anything else that people should do?
Well, it's just basically keep calm, use common sense, and work through it. But there is work to be done. I think that's the key thing. It's just like, you do need to get on with it, and it's going to, it's worth it, and it can really help your reputation as well once people start looking at this a bit more closely.
Fine. Okay. One final message from me is if anybody's considering GDPR and what it means in the context of working with Candidate ID and our amazing talent pipeline software, then rest assured we're all over it. We're working with Helen and with lawyers, and in the next few months we're going to be able to write manuals ourselves about this. So thanks very much for everybody who's turned up for the session, and look out for our next talent talk in 2 weeks' time, which is going to be to do with, I think it's to do with programmatic advertising. So thanks very much, and bye for now.
Okay, bye.